I will now call 123-797, State of Kansas versus Tyler Brandon McDonald.
May it please the court, Kristen Patty for the appellant Tyler McDonald. Saturday evening, it will be 4 years since Mr. McDonald was sitting lawfully parked in a parking lot and appropriately parked in a parking lot near the entrance of Milford State Reservoir out in Gary County. He was on the phone talking with his mom when there was a insistent and impertinent rap at his car window. He rolled it down and it turned out to be a sheriff's deputy who then smelled the odor of marijuana, searched his car, found marijuana, found drug paraphernalia, and that's why we're here.
Would this be any different if there had been no car? Everything's the same except your client is just standing where he was talking to his mom. And the officer just walked by to say, hey, how you doing?
Well, I think at that point, it would be how close maybe he approached Mr. McDonald, first of all. Second, if there was no car, if no car in sight, it would seem that Mr. McDonald might have needed a ride, correct? I mean, I suppose I'm not familiar with the reservoir. I suppose some people might park one place and then do some sort of a walking or running loop. That seems, of course, a little bit not quite as obvious at 9:15 at night. But if there was no car, then there might be a need for a ride.
But your answer's not taking in all the facts. Justice Stiegel saying the only difference is your client standing there. So the facts would be the officer comes up with his car, turns on his emergency lights, gets out and says how you're doing. That's a seizure, right?
It can be. Certainly, if Mr. McDonald had no car, then Mr. McDonald still would have been free to have walked on.
With the emergency lights going on. And I mean, I think we have case law of pedestrians going around and the police car stops, the lights go on. And we've said that's a seizure.
Right. And there's one unpublished opinion that's discussed in, I think, both briefs and in the Court of Appeals opinion, Dion, where the defendant was lawfully and appropriately just walking on a street. There were no sidewalks, but there wasn't otherwise any obvious impairment. And that case, it was a seizure, and the motion to suppress, I think the state had appealed in that case. And so that the trial court's granting of the motions to suppress was affirmed. What is, I suppose, different from this case from many of the others that the Court of Appeals, particularly in the majority opinion, relied on, is it was not like in the middle of the night. So many of these cases, it's 1 a.m., 12:40 a.m., 2 a.m., 3:30 a.m., something like that. It's dark, but again, the park was still open. There's also no, in at least 3 of the cases, there's some report in 2 cases specifically about the person who ended up being the defendant, that someone was concerned that he might be suicidal. Another case in Schuff someone called 911 because they saw a car just drive through a dead end and they were worried that someone might have gotten stuck. So there's no 911 call or specific information that the officer has about this car. I also thought it interesting that at one place, the deputy says that I would have checked his name and, okay, you're not somebody I'm looking for that was possibly in danger or in danger of self-harm. And then he would have been free to go. But I don't think that there's any place in the record where the deputy said, oh yeah, I had a report that I was looking for this guy. It turned out not to be him, but I was looking for somebody in a vehicle that matched this. So we don't have any of those facts here. The Court of Appeals, when they, in the majority of opinion, at least, when they affirm the district court, they call these circumstances somewhat unusual. We also have in Nicholson, the driver had pulled off on Highway 24, I think in Thomas County, and where there were no outbuildings or anything like that. Again, the contrast here is that Mr. McDonald had the right to be where he was when at the time that he was there. Change the facts, for example, and make it even like an hour later or whenever the park was closed, it might be different. But at least at 9:15 at night, the park was still open to visitors. Not getting a lot of questions today. I think I will save the rest for rebuttal. Thank you.
Chalmers?
May it please the court, this date appears by Assistant Solicitor General Natalie Chalmers. The touchstone of the Fourth Amendment is reasonable. What the officer did in this case was reasonable. The officer.
Can we agree this was a seizure, that the district court was wrong when it said the Fourth Amendment's not implicated here?
No. I do recognize that the state did not argue voluntary encounter, but I think the state could have won as a voluntary encounter here. The lights were on, but the car was 20 feet away. Lights being on, this court has never held as a per se seizure each and every time. There are other cases where the lights are on that it's not a seizure.
Didn't the patrol car park so that the defendant in this case couldn't back up and get out?
The district court specifically found the defendant could leave. The deputy, I think, testified he was about 20 feet away, and the deputy himself testified that he could leave. So based on the district court's findings, yes, he absolutely could have left. He could have gotten
Problem
out.
with that is the videotape doesn't show that.
Right.
So now we're into substantial competent evidence supporting the findings that you're relying.
The defendant here has never argued that substantial common evidence
Let's
does not
set that
support
aside
that.
for just a second. Let's just focus on what we really have.
Is the
here.
video part of the record? Oh, when the table of contents I looked at, the video is not part of the record, but I could be mistaken there. If you have it, I guess it's part of the record.
But if the video doesn't line up with what the district court found,
Well, the video was
no
of,
substantial competent evidence. And that was talked about in Judge Hurt's dissent as well.
I don't remember Judge Hurst's dissent saying that he could not have gotten out at all. I did not review the video in this case because I didn't think it was part of it. I did review the picture. I do think he could have gotten out. He was in a parking lot.
What is that? You're saying physically, like there was no physical barrier for him?
I'm saying he could have moved his
Okay.
car and still not hit the deputy, which is what the deputy clearly testified to. But yes, there was nothing also he could have actually,
But your
physically left
argument
the
is that that would have been perfectly fine. Deputy would have just said, oh, see ya, you're on your way.
I think if he'd actually gotten out of the car, he could have still said, are you okay? Okay, great. And then they would have gone on. Yes.
No, but he could just drive on. You've got the lights going on and nobody wants to talk about that, it seems to me. But once that officer turns on those lights, there's an encounter happening here. Well, I mean, you're not going to ever argue that people are entitled to walk away
They do.
from the police when their lights have been turned on like this.
We've had passengers walk away in car stops where the police actually seizes the driver. This court has not said ever that I am aware of that every time the officer flips on lights, that everyone around has to stop as a matter of law. Everyone seized. Here he flipped on lights,
Only
yes.
one person here.
Yes, there is only one person. But I don't, even if there's only one person, I don't think this court has ever held as a matter of law that each and every time an officer flips on the lights, that is automatically a seizure. I
Let's-
don't think that's the
Let's
case.
take
law.
it, not from the perspective of this court, but from the perspective of an ordinary citizen. Are you making the argument that an ordinary citizen in Kansas believes they have the right to leave when a patrol car pulls up behind them, parks, and activates its lights?
Apparently, not only do they believe, they actually do that. I do think that across the country, courts have repeatedly
I know,
found that
but
just turning the lights on is not a seizure under a reasonable person standard. I'm sorry.
Maybe you answered my question. I'm not sure if you did. Is it your argument that the reasonable Kansan, the average Kansas citizen, thinks his or her own head that when a patrol car pulls up behind them and activates their lights, that they are permitted to just drive off?
Yes, in some circumstances. I think if you have the sirens on, it's different. Here he had his back lights on. He didn't have his front lights on. I think
I don't find that very plausible. That
We've
might just
had-
be a personal disagreement we have.
I understand that that is going to be a popular personal disagreement probably, and many people might side with you, but the case law supports me. There are cases where you have two cars stopped and the officer's like, I wasn't trying to stop you, goes around. I mean, it's not, there has never been a per se rule that just because the lights are on, there is automatically a seizure.
But that's not, let's just to get rid of this. Those aren't the facts here, because we have the lights, the getting out and the knocking on the window and the officer talking to him.
Okay.
So with those additional facts, would you agree it's a seizure?
Still no, but I think here, if we're under the welfare check, it really doesn't matter if there's a seizure or not. You're allowed to seize for the purposes of a welfare check. So the question is whether the welfare check is reasonable. Do I think that there was a seizure here? No, I think this should have been argued as a voluntary encounter, and absolutely is a voluntary encounter. Officers should unquestionably be able to approach literally anyone. They can even do knock and talks at the front door and say, are you okay? Here, the officer is in a secluded park that has, quote, a lot of issues at the park that people go out there to either self-harm or to conduct illegal activities.
Let's talk about that statement. Isn't it true that you have to have sufficient specific articulable facts? So in other words, there were two crimes here, there were two suicides here in the last 3 months. And, in a situation very similar to this, to just say, this is an area where, I forgot what the language you used was, where stuff happens. Would you say that that's specific and articulable?
Yes, I would. And this court specifically in cases where there's just, they say it's a high drug area. We don't have to sit there and go, we've had 20 incidents of finding people with drugs in the last month. That's never been required. I think on cross-examination, they could maybe challenge that and say, well, how many has it been? But we've never said you have to have how many numbers, how many people have to commit suicide before officers can be concerned for other people? I don't think there's a set rule.
What was the basis for concern here? You got a guy talking on the phone.
First of all, he didn't know we had a guy talking on the phone when he pulled up.
But he's got his headlights on and he pulls up behind him and he can see. And even then he goes to the window, peeks in, he sees a guy talking on the phone.
He does not, actually, that is not supported by the record. There is never anything here where he says he sees a phone. He says, I think he was on Bluetooth. He said he was talking to his mom. So we're all assuming that he was on a phone conversation with his mom. Nothing contradicts that. But the idea that he could see immediately that he was on the phone, I think is a bit of a
That doesn't
stretch.
weigh in your favor because, there's nothing in the record. This guy says he's on the phone. There's nothing to contradict that, right?
We don't look at it from what the guy says later. We look at it from what the reasonable officer would hear someone talking. Yes. I don't think just because you hear someone talking that means, oh, okay, they're okay. There's nothing wrong.
Okay, so
I don't
let's say
see-
he's not talking on the phone.
I think an officer can go up and tap on a window and say, are you okay?
Is that true is there an instance where that isn't, that's just, is every encounter with a police officer voluntary?
I think if they pull you over, if you're moving along and you're in a car and they pull you over, that's going to be a seizure if you have to physically pull
Right.
over. But anytime you are just being
I'm
stationary,
sitting there in the Judicial Center parking lot
yes,
on the phone. And officer pulls up behind me with his lights on or her lights on. That's an instance of a voluntary encounter.
well, here again, they didn't argue voluntary encounter, so we're in a public.
No, no,
welfare check, so I have to have some-
well, it seems you're arguing basically there is no, it's
Right, but I think
always,
what you're arguing, if I'm right, is that voluntary encounter aside, this, we're going to presume this was a seizure, but there was specific articulable facts to justify a public welfare stop. And so if we say, take into account and say, you know what, he wasn't on the phone. Okay, so I'm sitting, or Justice Rosen is sitting in the Judicial Center parking lot
That's not,
at night, okay, when offices are closed, that an officer can turn on the lights, park behind him, knock on the window and say, hey, are you okay?
yes, actually, because I'm not sure why you would be in a parking lot at the Judicial Center at night. Here you're in a
really?
parking. Well, I don't know why you'd be
Take
sitting
my
in your
word.
car for any extended
I-
time. Why you wouldn't make your phone call in the office while you're here at night?
Well, where do we draw the line? I mean, then what's the point of having a public safety exception if there really isn't anything except you're saying this general thing, oh, there's been, again, I forgot the words that were used, some general thing, there's been
A lot of issues out at the
a
park.
lot of issues, okay?
So either
So
self-harm or conductive
everything is
neglect
banked
activities.
on a lot of issues,
I
right?
do think, yes, everything is banked on a lot of issues. I do think in the,
Nothing else supports the
If-
specific articulable facts.
It's
Just there's been a
dark.
lot of issues.
no, it's dark, it's secluded. He's sitting in a parking lot and most people don't just hang out at parks in the parking lot with innocent activities and or not causing
Really? Do
harm to
you have-
themselves.
I mean, my experience is that, my kids do that. That's where they go to talk on the phone because they don't want me to overhear them. I don't understand. You're just making these generalities. People do that. I mean, the park was open.
Yes, the park was open, but officers are not required to also assume innocent activity all the time. They're allowed to use their
This isn't an
history and
innocent
investigation.
activity. This is public safety. So let's be clear there. He said that he didn't knock on the window because he thought he had reasonable suspicion that criminal activity was happening. Okay, he's saying, I worried for this guy's welfare.
And I don't think there's anything that suggests that that's not true.
Right, but do you hear what you're saying? There's nothing to suggest that's not true. I want to know what is in the record to suggest that is true.
His own testimony. This is a preponderance of the evidence standard. It's not beyond a reasonable doubt. I think the dissent went off the rails on A, B, basically holding the state to beyond reasonable doubt, B, using the wrong standard that is contradicted by the United States Supreme Court and hasn't been adopted by this court, and C, making factual findings that do not exist. She says things like the deputy asked McDonald to roll his window down. That's not in the record. I don't know if the knocking is what she meant. She says, well, she actually advocated for the defendant himself by making the whole license plate thing, which so far has not been talked about. That was not argued below. It was not mentioned in the Court of Appeals brief. And she talks about how that somehow matters. No one's ever briefed that. The totally divorced, sorry.
Setting aside maybe what your objections are to the dissent in the Court of Appeals, how would you best articulate the specific, objective, and articulable reasons that are in the record for the stop?
It was dark. It was in a secluded area that they had a lot of issues of public or of self-harm and illegal activities. That is what I have. Those are reasonable, I think, for the officer here to be concerned about whether or not this person who's just sitting in a parking lot needs help, if he is okay or not. And
So
all the
it's
officers.
really this is a suicide check.
Yes,
That's the argument.
that is
we're left with.
specifically what the officer testified to, and yes.
And what we have in support of what we have that's specific, objective, and articulable in support of that is the time of day, the fact that the individual was alone, and what in terms of a historical record.
The historical record we have is the deputy just saying he himself witnessed a incident of self-harm, murder, suicide. And then we have him saying that there is a lot of issues in this particular park with self-harm and illegal activities.
Why the lights?
The lights, he said, were for his own safety. He said it was so that if something went wrong, the officers could be able to find him, and so that the person that he's approaching probably doesn't think he's there to rob him.
Own safety.
The officer's own safety. The officer
you-
testified the lights were for officer safety.
Wearing a uniform, right?
He is wearing a uniform at night. The lights do help illuminate.
So if it's a welfare check, why does he need the lights to protect himself?
Because people might startle easily when I don't. And also because he said if anything goes wrong, the other law enforcement can find him easily. I think it is common, honestly, for all police officers when they're doing much of anything at night to do lights so that people can see them and know who they are. I think that's perfectly reasonable.
And we have to keep in mind that, talking about it being dark and all that, it was 9 o'clock at night, right?
Yes,
In September.
correct.
So tonight at 9 o'clock, however dark it is, the situation. Might have been. I do want to let you know before you go run back to try to find the video that what I was mistaken about was references to the dash cam video in the testimony about that. So don't have to go run back to the video.
Oh, okay. I still stand by, the officer said he was far enough away. The district court made that finding 20 feet. There is a picture that I know is part of the record. I did look at that. And the officer did explain that the picture shows where the reflection of the lights are, but is not necessarily an accurate reflection of where he was in relation to the car. So I do think you still have the 20 feet. Even the defendant himself said he could have gotten around the officer. But it was, he said something about having to go into oncoming traffic or make a U-turn that would have apparently been inconvenient.
Didn't he
And just
say
the
he'd
te-
have to take he'd end up on a dead end?
Yeah.
He'd have to turn into a dead end and then have to come back to the officer. So he really couldn't leave, as
Well,
I recall that testimony.
I don't know that I agree with the classification that just because you have to make a U-turn that is inconvenient for you means you can't leave, but
Well, I think the way I recall the testimony was he'd go down into a dead end and he'd come back and he would still, to have exited, had to, the officer would have blocked his passage, but I don't know that it really matters, but yeah, anyway, it was something along those lines.
yeah, I think
But
he's,
at what point
Sure.
does
That was too
as you gather facts, as you approach, you still, because your initial goal is to do a welfare check, after you get there and you're hearing somebody talking, you may hear, I don't remember how clear the record is about whether there were two voices, but you could hear somebody talking. Is there at some point where you turn around and you go back, or do you always, once you've left your car, you're free to go into the point that you have asked that person to roll down their window?
well, here he did also just, I'm gonna answer one thing and then come back, but here he didn't.
Tapped on the window.
He tapped on the window. He actually said that he didn't have to roll the window down. He did say it was customary that when you knock on a window, that's what most people do, but that he could have left the window up to talk to him. I am unaware of many cases where once the officer starts to approach that they ever stop, because they're trying, I think, typically to explain to the citizen why they did whatever it is they did in the first place. So here, yes, he heard someone speaking. We don't have in the record what that conversation was at all. There is nothing that I am aware of. And he just went up there and knocked, but I'm not sure that just hearing someone speaking, well, I do not believe that hearing someone speaking negates the original good intent of the officer here. I think there might be some circumstances where that happens, but just because someone's actually, depending on the speech itself, could show that there was some kind of medical emergency.
Let me ask you this, is there anything in the record that confirmed his initial concern after the officer left the car and before he knocked on the door?
No new additional information came to light that would have supported the fact that he was in need of a welfare check. Oh, I am out of time.
About to keep going.
Okay, I Just want to harp one more time on the totally divorced language. I hope this court at least overrules that. That is contrary to United States Supreme Court precedent, and the Kansas court, or this court, has never adopted it. They didn't do so recently in Ellis. The state would respectfully request that you affirmed the district court and the Court of Appeals in this case. Thank you.
You reserve 2 minutes.
Well, I guess first to dovetail to the argument before me, you can always at least rule that section 15 is more restrictive if you want. The good intent of the officer, I don't know that that's in the record. To clarify on the video, I did request that body cam video be added. I had a little bit of trouble in now 2 years ago, October 21, getting the exhibits from the prosecutor added. And I can't recall exactly why the video itself wasn't added in the end. The license plate thing that my colleague referenced, I haven't hung a whole lot of put a whole lot of weight on that. I think Judge Hurst put a lot more weight on it than I did. My big problem is, at least for under the facts of this case, is that once he got around, able to look through the passenger side window, saw everything, that it was okay, that he just didn't go back to his car. I think, and then the knocking, I think that does make it, certainly if it isn't a seizure before, it's a seizure then. You have to talk to me. You have to talk to me. I dispute that it's secluded. Again, no one else was there, but it was a parking lot near the entrance. It wasn't like it was off someplace else in the reservoir or off a road. If my client had, for example, seen the officer nearby and rolled down the window on his own, then maybe we might be arguing whether the encounter was
What do you-
voluntary or not, but those
what do
aren't the
you-
facts here.
I'm sorry.
That's all right.
What do you make of the officer's testimony that there had been a lot of self-harm at the park? And maybe I'm adding to his testimony under similar circumstances.
Well, he didn't really elaborate on that. I mean, he mentions on one page, be page 14, that there was one incident of murder-suicide that he was involved in. You know, by his logic, then I guess anybody who is parked in a parking spot and any hour that the parking lot is, that the park is open, is potentially approachable.
What if this would have been on a bridge? And bridge at which there had been 3 suicides in the last year or whatever.
I think generally people don't park on bridges. Yeah.
I guess what I'm driving at is how are we to draw these fine distinctions? I think this is what Justice Wall also was trying to ask. In other words, I take it you wouldn't suggest that prevention of suicides in a public place is an illegitimate reason to make a public safety stop.
I still think that there has to be, if not particularized to that car and person themselves, like in a couple of other cases that have been cited in the materials, at least some other thing. I was looking for so-and-so who drives a vehicle very similar. I was not provided a license plate, you know, it's something like that. He didn't say that he was looking for anybody who was suicidal.
So just, we know by recent history that this is a common place for suicides.
We know that there was one murder.
No,
suicide.
let
Okay.
me change the
Okay,
fact. I'm just
okay.
trying to pin you down on how much leeway there is for law enforcement to engage in suicide prevention. I mean, that's how I see this case. I think at least that was the proffered argument, is I'm engaged in an effort to prevent suicide.
Still, people have a right to be where they want to be. If Justice Rosen wants to sit in the parking lot of the Judicial Center and make a phone call before he leaves, because after all, that's the safer thing to do, right? You're not supposed to be on the phone while driving.
So your argument is basically just that that's not an objective, reasonable reason for making a public safety stop.
No. And the phone, just to kind of clear up that, on page 15, he did say, I don't know if he was holding the phone, but yes, I could hear that. Like, I believe he may have been talking on Bluetooth, so he could at least hear a conversation. Completely out of time, unless you want to give me my 7 minutes back. Then no further questions. I would appreciate if you would reverse the Court of Appeals and the District Court, and Mr. McDonald's convictions. Thank you.
Thank you. Thank you to both counsel for your arguments. We will take this matter under advisement.